Hello, welcome to our webinar. I'm Aseel, for those of you that don't know me, Aseel from Frazer Jones. I lead the commerce and industry team, and I'm joined by Emma O'Connor. We'll do introductions in a minute. We'll just wait for a few more people to join. And thank you all for being so prompt. Yeah, okay. Well, look, we've got lots of people joining, and I can see the numbers shooting up as well, but I'm mindful of your kind of precious lunch breaks as well. So, hello to everybody. This is a wonderful collaboration between Doyle Clayton and Frazer Jones. Um, and we're here today to talk about the Employment Rights Bill. This is a very hot topic for all HR professionals, which we'll kind of go into in a bit. And this webinar focuses on one aspect of that really deeply, which is navigating the recruitment challenges. I'm delighted to be joined by Emma O'Connor. Hi, Emma.
Hi, Azil. Thank you so much for having me.
Emma is actually partner at Doyle Clayton and head of client training. So I'd like to just set the scene and say that please don't take this as like kind of a deep dive into the Employment Rights Bill. Don't go away thinking this is like official legal advice. This is guidance, and we're skimming, a lot of topics and then kind of deep diving into the recruitment. I'd also like to let you know that the chat has been disabled. And any questions you have that pop up over the course of the kind of this webinar, please pop your questions in the Q&A and we'll come to them at the end. So 12:32, let's get going. So Emma, over to you.
Thank you, Azil. Thank you so much for having me as well. So, yes, as Azil said, this is going to be a discussion about the Employment Rights Bill. Where are we now? But then having a look at the recruitment aspect in particular. And as Azil also said, this is just an overview. It's not giving you any advice, but please do reach out to either Azil or myself, and we'll give you some details about how you can do that. So, the Employment Rights Bill, where are we now? Well, interestingly, not really further forward than when I was sort of discussing this with Azil, obviously back at the beginning of November, and obviously we were talking about, what topics we wanted to discuss. So we aren't really any further forward. We are still at the consideration stage. But actually, it is quite exciting because we are in this weird sort of phase of a thing called parliamentary ping pong. And essentially, what that is that the Employment Rights Bill has passed through the House of Commons, but before it can become law, before it can get royal assent, it has to pass the House of Lords. And things have not gone particularly smoothly for the government. And in actual fact, the House of Lords have rejected key elements of the Employment Rights Bill and have continued to do so. The latest date that it went before the House of Lords and they rejected it was the 17th of November. The key sort of sticking point, and actually the one that we'll be looking at, and Azil and I will be talking about in this webinar, is around the government's proposal to introduce day one rights to bring the statutory claim for unfair dismissal. Now, their lordships have said, actually, we're not quite sure that this is really what businesses want, and we don't think this is, what's right in terms of the economy and for employment purposes as well. And they've suggested instead that, why don't we have, rather than a day one right, let's bring in 6 months. So employees have to work for 6 months before they get the right not to be unfairly dismissed. They're also not happy about a couple of other points in the Employment Rights Bill, mainly around guaranteed hours for zero low hours and agency workers, and also some changes to trade union rights. But it's really the 6 month suggestion that they've made that's really causing issues, because the other point is that this bill was supposed to pass before the summer recess. It was supposed to pass in September. Certainly, this was all supposed to be done and dusted before Labour Party conference. But here we are heading towards Christmas recess. So Parliament will recess on the 18th of December, and everyone will be back on the 5th of January. So in terms of the time for this to continue this process of sort of, going back to the Commons, they obviously have to consider the House of Lords amendments, whether they're going to accept it, go back to the House of Lords, will they accept what the government are trying to do? Obviously, time is ticking because as we know, the government are proposing that certain things are going to happen as soon as this bill is passed with regards to trade union rights. But the big date for us as employment lawyers and yourselves as HR professionals is really April 2026. So as you can imagine, there isn't a huge amount of time when we think about that timetable that the government have released. So everything's to play for. We know that the government are keeping their cards very close to their chest in terms of what certain rules will be, particularly in regards to what this initial period of employment will look like, what is the modified procedure, in a chance to sort of say to the House of Lords, look, don't worry, we've got it covered. We are going to give employers a chance to consult on what we are proposing as maybe a bit of a sweetener for them to accept their changes. So who will concede? Don't know. This is going to pass. It will pass. The question is when and in what form. But I think that overall, regardless of where we get to with unfair dismissal rights, whether it is from day one or after 6 months of employment, really the messaging and the challenges and the sorts of things that employers and HR teams, and in particular managers, need to be focusing on now doesn't really change. And I think that's one of the kind of the key takeaways from this. Yes, we are in a bit of a limbo. Yes, we're in parliamentary ping pong, but it doesn't really change what we need to be doing and what we need to be focusing on, and certainly some of the challenges that Aseel and I will be talking about later. The other point about the Employment Rights Bill is that once it is passed, it doesn't do very much of itself. It needs lots of pieces of secondary legislation called statutory instruments to actually kind of bring its plans into being. And one of those is obviously around unfair dismissal rights. It doesn't change it of itself. We will have to have some consultation, and then the actual law, the actual details of it will be brought in under secondary legislation. So there are a lot of unknowns about what the final piece of law is going to look like, what employers are going to be expected to do. But I think we know enough from the direction of travel and certainly the mood music to understand and to give some sort of tips about what employers should be thinking about now. The other point to say is that we have time, but as we know, time, particularly in the world of work, particularly when we try and think about changing contracts or changing policies or changing HR practice, that time goes very quickly. So we need to factor that into, our messaging and our communication with our senior leadership teams, with our boards, and with our management populations. Is that, okay, you might think you've got till 2027, but actually we've got an awful lot of work to do before we get there. Now, when we think about the Employment Rights Bill, there are lots of words, aren't there, that have been used. It's been called a game changer, once in a lifetime opportunity. And, often those words, don't they get slightly overused. But I do think with the Employment Rights Bill that actually it is a game changer. And one of the reasons for that is because its tentacles, its reach, its scope is so big and so potentially impactful on the way business, workplaces, employers operate. It really does touch upon everything that you do as an HR professional, from recruitment, selection, hiring, onboarding, our probation periods. It impacts the way in which we may in the future want to change our terms and conditions of employment. It affects the way that we perhaps want to resource our workplaces with things, with changes to the way we engage with 0 and low hours workers. It also impacts upon family leave. It increases the protection potentially for women on maternity leave, women who are pregnant. It impacts the way that businesses potentially want to manage their workforces in terms of, redundancies. It increases the potential risk of compensation, again, around collective redundancies. Also, it changes the way in which employers are liable for certain types of harassing behaviours. So it increases and introduces third-party harassment and third-party sexual harassment. Also changes to the liability for sexual harassment, this increasing of the reasonable steps duty to all reasonable steps. So again, lots of work to be done there around risk assessing and in particular training for managers and boards. As one would expect from a Labour government, it increases the rights of trade unions in a way that many businesses and for many employers, and actually for many HR professionals, they are not going to be used to. This way that employers are going to have to tell their workforces that they are able to join a trade union. Again, this is a cultural shift that for many of you have never been, exposed to. Also, it's going to have an impact on sickness absence and sickness management, and in particular sickness costs. The changes to SSP, it's going to become payable from the first day of sickness absence rather than having those waiting days. And also the amount of individuals who are going to be entitled to it is going to increase as well with the removal of the lower earnings limit. So again, lots of work to be done. Also, a new agency, a new non-governmental agency is going to be set up with potentially, very wide remit in terms of its powers, which is going to be called the Fair Work Agency. So again, some issues there to think about. But obviously the big one, and one which will have a huge change, I think, whether it is from day one or whether it is from 6 months, will be the proposal to change the current law and the current qualifying period of service for unfair dismissal. The other point just to say about the day one unfair dismissal rights is that it is a manifesto pledge. Now, manifesto pledges can come and go as we have seen, but it's one that the government is saying, look, it's a manifesto pledge and we're sticking to it. Now, whether the House of Lords, continue to put up a fight, sometimes, when things are a manifesto pledge, they often just say, right, okay, we won't continue to challenge it. But I think the fact that, the government are sticking to it at the moment is indicative of perhaps what they want to happen. So yes, it is a game changer. Yes, it is going to have a huge impact on pretty much every facet of the employee life cycle from recruitment until dismissal, but also, looking at rights for those individuals that we engage either through umbrella companies or through zero or low hour contracts as well. So this is what it looks like. This is the current timetable. And if anybody would like a copy of this, then please do, drop myself or Aseel an email at the end and I'll send it to you. But really the key dates at the moment, again, thinking about the timetable, obviously we're looking at this being past late 2025. And the first sort of key date, as we know, April changes. That's kind of what we have already in our kind of, factoring in timetable. We've already seen, haven't we, that the government have upped national minimum wage, that's going to take effect from April as well. There'll also be some other statutory rate changes as well, statutory sick pay, maternity, adoption pay, those other statutory pay entitlements as well. So really April next year is kind of a key date, a key month that we need to be working towards and thinking about the changes there, particularly around the family leave changes, parental paternity leave, and also looking at the changes there to SSP. And then as we move forward, October. So the kind of if you can, the sort of the steps get sort of higher and obviously those sort of bigger ticket items, although I think pretty much all the changes are pretty huge. But, those sort of bigger ticket items like the day one unfair dismissal rights or changes to unfair dismissal rights, wherever we end up, and looking at the guaranteed hours rights as well. We're looking at 2027. Now, we don't have a date for that, whether that's April or October. I'm erring on the side of it being towards the end of the year, just because there is so much that needs to be done. We are talking about a piece of law, piece of legislation that of itself is like way over 300 pages, and the amount of consultation, documents, ACAS codes, guidance, statutory instruments that have to get done and have to get passed, before all these things can happen, it is massive, and it is a massive task and a massive undertaking. When you think about all the other massive tasks and massive undertakings and the amount of, bills and parliamentary acts that need to go through as well. So there's lots and lots to do and lots to be done. So again, if you'd like a copy of this, then do please email us. I think it is worth talking about the day one unfair dismissal rights in more detail, and obviously what it will mean to recruitment. And I know Aseel's got some thoughts on how this is going to be impactful from a recruitment perspective. Now, as we know, and again, what unfair dismissal claim is ordinary, but when you're looking to end someone's employment, there are lots of rights and lots of legal things that we need to consider. We need to be looking at contracts of employment as well. But under the Employment Rights Act 1996, there is a statutory right that employees have not to be unfairly dismissed. And employees, and again, it's an employee right, and to bring that right, employees currently need 2 years continuous service. Yes, employees, and actually a wider category of worker, have rights under the Equality Act, which actually applied before employment or work has started. So yes, we can't forget those other rights that employees have under the Equality Act. And yes, there are certain rights to bring automatic unfair dismissal claims where, again, you don't necessarily need the 2 years qualifying service. So there are rights that individuals currently have, regardless of this sort of, right to bring a claim for ordinary unfair dismissal. But on the whole, to bring a claim for ordinary unfair dismissal, yes, that's brought in the employment tribunal. And essentially, the employer will have to show that it had a potentially fair statutory reason to dismiss an employee. And again, these are all set out in the Employment Rights Act. And it must show that it followed a fair process. And again, what that process looks like will depend on the circumstances. So, for example, if it's a redundancy situation, which is a potentially fair reason to dismiss, again, your process is going to look different than if your process is linked to somebody's capability or qualification. Again, another potentially fair reason to dismiss. Obviously, again, with things like redundancy, again, remember, it's not just individual rights. We have to think about collective rights as well. So again, it's always worth just taking advice, when you are thinking about or proposing to end someone's employment. And the other point about bringing a claim for unfair dismissal and an employer being able to successfully defend that is, yes, you need a fair statutory reason. Yes, you need to follow a fair process, but you also need to act reasonably in all the circumstances. So was the reason that you chose, was that reasonable? Have you acted fairly and reasonably in all the circumstances of the case? So again, just to repeat, always worth taking advice. The other thing to note about the proposed change under the Employment Rights Bill is that it will be a permanent change. Now, some of you will remember that, rights to bring claims for unfair dismissal have been 12 months. They are currently 2 years. We did have, back in the 1970s, it was 6 months. So it can change. And governments tend to bring, governments of whatever colour tend to bring in, their own sort of, what they think is an appropriate length of time for somebody to bring a claim for unfair dismissal. But often what we see is when governments do that is they change it by way of a regulation. There's a way that governments can change the qualification period without having to go to Parliament every time to change it. So they've got the flexibility in some respects to be able to change the length of time. What's really interesting about the way that the Labour government are proposing to change the period of time, or to, in fact, get rid of it altogether, is that they want to do that by way of an Act of Parliament. So really, once this changes, it is a permanent change. Yes, an Act of Parliament can change by way of another Act of Parliament, but, let's face it, there's probably, if we do, get a change of government, who knows, in 2029, there are probably other things on the to-do list rather than changing certain parts of the Employment Rights Bill. So that's why it's really important to focus on this. And again, during consultation processes when they are launched, is to really kind of, get involved and have your voice heard. What I also think is really interesting, and this is a chart that's been produced by the Resolution Foundation, is actually if you look at this chart, this is obviously where we are now, November 2025. If you look at this chart, obviously, the United States and Canada don't have any unfair dismissal laws as such. But, yes, we are, out of step with many of our European counterparts. Most will have, around the 6-month mark, maybe 3. But if we look at this and if we move then to think about having no qualification service period at all, it puts us sort of at the other end, doesn't it, of the spectrum, where, there aren't many countries that don't have any service qualification provisions. So it's a really interesting way of looking at it. Are we then, yes, potentially, one could argue we're out of step. But again, if we move to having no qualification period, are we again out of step? So I think this is quite a useful way of just kind of, showing audiences actually why this change is so potentially huge, not just from an individual employer perspective, but just kind of how we are as a nation in terms of, employment rights as well. So what will it be? Unfair dismissal rights after day 1 or after 6 months? And does it matter? Yes, of course, if it is going to be after 6 months, so an individual will need to be with you after, for 6 months before they have that statutory right to bring a claim for unfair dismissal. Obviously, it is one less thing maybe to think about, but, automatic rights, discrimination rights, 6 months when we think about recruitment and when we think about probation periods in particular, isn't really a great deal of time. So my view is that regardless of where we end up, and I'm not putting any money on this horse because I don't think it's a safe bet, actually. I was pretty adamant that it was going to be from day 1, but after seeing the House of Lords vote and the fact that the number of Lords who voted no has not changed, I'm not entirely sure where this one will end up, but I don't think it really matters in practice. I don't think it changes what employers, HR teams, managers, and senior leaders need to be doing. But interestingly, the government say that if it is a day 1 right, it will give the statutory right not to be unfairly dismissed and to bring a claim against the employer. It will potentially mean that 9 million more employees will have that right, or potentially 6 million more if it's after 6 months. So again, huge figures, huge amounts of individuals there potentially. And when we think about the backlog that we have in terms of cases in the Employment Tribunal, one wonders whether our creaky Employment Tribunal service could cope with 9 million additional unfair dismissal claims. So just to sort of talk you through the headlines, really, if we get to day 1 unfair dismissal rights, the government have tried to soften the blow somewhat by saying, look, yes, everyone will have the right to bring a claim, but look, we're going to give you a little bit of comfort, employers, and we're going to bring in this initial period of employment. Again, could be 6 months, could be 9 months, we don't know. But basically what the government is saying that, you can make dismissals during this initial period of employment, but you've still got to have a statutory reason and you've still got to follow a fair process. But what they're saying is that that process might be what they are calling a lighter touch. Possibly compensation might be reduced if you do dismiss somebody unfairly during this initial period of employment. Currently, the maximum unfair dismissal compensation is around about 140k or 12 months salary, whichever is the lower. So it's a claim with teeth. Whether it's going to be any less, we don't know. And obviously, we're looking at a 2027 sometime then type date. But again, watch this space. So initial period of employment, but it does not mean, and this is not a statutory probation period as such, you don't have 6 or 9 months and then you can dismiss people within that. You still have to have a potentially fair reason, and you still have to follow a process, albeit what the government is proposing that in certain cases, and just to be very, very clear on that, in certain cases, an employer might be able to use what they're describing as a lighter touch. So if you are proposing to dismiss an employee during the initial period of employment for capability, qualification, conduct, breach of a statutory enactment, or employee related some other substantial reason, then yes, there may be this opportunity to use a lighter touch process, which could either be a meeting with a companion or maybe some sort of more complicated, exotic ACAS type code, but we will have to wait and see. But what's really important is to remember that firstly, we don't know how long this initial period of employment is going to be. Also, please take note that it is only potentially available in the circumstances where you are not proposing to make somebody redundant, or you're going to be relying on something like employer, some other substantial reason. So you're going to be going through a business reorganization. So again, you will not be able to use this lighter touch process in those situations. And again, please note, obviously, collective consultation as well. There will be some consultation before we get to sort of final stages. And again, we need to be thinking about our probation periods, and we need to be thinking about our notice periods as well, particularly if that initial period of employment is going to be 6 months, because I think that's really quite tight. And again, please be careful, remembering again that if you are using fixed term employees, fixed term employment contracts, it's still a dismissal. So again, we need to be thinking about fair reason, fair process. So please do take advice when ending a fixed term contract. So that's a gallop through, Aseel, in terms of obviously where we are now and what we think obviously this new process is going to look at, and what it's going to be potentially. But I do think that there are some, as I said, we don't know all the detail. We're very light on detail, but we do know roughly what it's going to look like and the direction of travel. And as I've said, whether it's day one or after 6 months, I think there are things that we've got to do. And you and I have been talking, haven't we, about what some of those challenges are. And really, from your perspective, Aseel, where do you see the sort of the key challenges?
Yeah, I mean, look, there's a huge amount to unpack here, and I'm sure hopefully everyone's heads are kind of like not spinning with the prospect of this in terms of how you're going to navigate this within your organization. But specifically from a recruitment perspective, lack of engagement with recruitment. So how often do I hear candidates telling me that they've had, 10, 11, 12 stages in a process, or, that kind of thing happening? And I think what we need to make sure is that, yes, recruitment processes will need to be more thorough, more rigorous. But that doesn't mean more stages, and that doesn't mean longer. I think a robust recruitment process will doesn't necessarily mean adding on more stages. And I think that's something that a lot of HR and talent teams can really start getting to think is like critically assessing their recruitment processes and how they operate. And how to be a bit more thorough. There's a lot of testing and, all those kind of other tools out there to kind of like assess individuals from various aspects as well. So will we see an increase in the use of testing as part of recruitment processes? And then there's another bigger conversation around testing and what kind of neuro makeups those tests speak to, and the whole other like kind of conversation as well. So there's a lot to unpack here, and I think knee-jerk reactions are kind of not the way forward. And what do these changes mean for learning and HR teams? So, we've seen teams get more and more lean. Over the kind of like last, I guess, in that kind of post-COVID world, we've seen a lot of learning teams and a lot of kind of OD teams in general, talent teams as well, kind of skeleton crews on the ground. So is this an opportunity then for those teams to really push for budget to increase their headcount? You know, is this finally the thing that the boardroom will listen to in terms of this is what we need? We need more, boots on the ground if we're going to roll out, more learning initiatives, more support during probation periods, onboarding, and induction programs that really mean something and capture hearts and minds and really like engage those employees from day one. So does that mean that we'll finally get those more boots on the ground, and then there's an opportunity there for more increase in headcount within learning, within HR, and potentially within TA teams as well? The next point's an interesting one. So, not understanding the role or job description. So, working as a third party recruitment supplier, we do see a lot of kind of those knee-jerk reactions when it comes to recruitment. Or we need someone like this, but we don't have a job description, or we don't have this. You know, you're kind of setting yourself up to not succeed in this if you haven't thought about the role properly. And there's another thing that I want to mention here, which if you have what I call a kind of pick me up and put me down relationship with your recruitment partners, I strongly advise you to kind of rethink those. Now is an opportunity for you to kind of get the most out of your recruitment suppliers. So, as a third party, as an external, I have some clients who will include, me from the very early stages. Next year, we're thinking about this, or our strategic growth plans will indicate that in Q4 of this year, we're going to need this. Let's start talking about it, and let's start quietly pipelining and thinking about this. Help me work out my budget, help me benchmark for this role, help me, what are my competitors doing in this space? We have so much more knowledge and we have so much more to offer than a lot of the kind of pick me up, put me down clients know. And I think there is a huge opportunity there to lean on us as a trusted advisor and have that more collaborative and long-term approach to your recruitment needs as well. I promise I'm not kind of giving it the hard sell, but we are capable. You know, a lot of us are kind of HR professionals, talent professionals, internal talent professionals. You know, we are capable of a lot more than some of our clients dare to acknowledge.
I
So
would
that
echo
will,
that. Yeah.
yeah, yeah, and
I
that
would
will
echo that
can,
as well from a legal
mm,
perspective, because I
yeah,
think you're absolutely right. I think that not engaging with the recruitment process early enough,
mm,
thinking about, even what do we need? What role are we actually recruiting for? Do we have people internally that we might be able to use? And then maybe scope out a different role. And so I would echo actually just that earlier engagement in it rather than somebody shiny is going to come in and they're going to, fix everything because, that rarely happens.
yeah, exactly. And that kind of will dissolve all of that kind of not understanding the role, not understanding the job description, not having a role, just having a kind of chat GBT job description available to you,
Well,
you know.
exactly. And I think, one question would be to you as well, surely this is what candidates want as well. If you want to be that, create that great expectation when people come for an interview or start work, you want to create that great first impression, so actually doing all of this must help with that as well.
It absolutely does. And you've got a very short amount of time to make sure that someone falls in love with the organization. You've got a very short amount of time also for you to kind of like lose the room and to make that candidate start to question, what have I done? Or have I joined an organization that's a little bit of a kind of shambles behind the scenes? And those early days are so important. And that clear onboarding process point here, and not just kind of giving someone a laptop and saying good luck. I hear a lot of horror stories from being a kind of insider here. And I think there's an awful lot that organizations can do. But again, that goes back to the earlier point about kind of boots on the ground and resource and, having those budgets. So now is the time to, get those budgetary hats on and start thinking about the resource you're going to need and fighting for that resource. Yeah, exactly. And then in terms of probation periods, I know Emma, we've talked about this a lot, haven't we? In terms of like, obviously potentially we'll have that 6 month period, but you indicated that that's quite tight, isn't it?
It is, yeah. And I think just kind of, just picking up on a couple of points that you mentioned, definitely, definitely, if you're looking at testing, psychometric testing, again, you really need to think about, how inclusive is that test recruitment processes as well. So really just to think about that. And the other point is about the job description. That is going to become crucial. That is going to become such an important document because if we are going to be making objective decisions about whether or not somebody can do the role without having a job description or a person and a person specification, how can we then say that somebody is or is not making the grade? So that job description is going to be so important. And I also think businesses are missing a trick with this onboarding process. I think you've got, in some cases, you might have somebody who's on a 3 month notice period or a 6 month notice period before they can join you. That is such a opportunity to get people to come to events. If you've got workplace events coming up, December, invite people
Mm.
to come. It's really nice. It makes them feel engaged. It allows them to meet other people within your firm, within your workplace. And actually, it's just a really nice time to kind of get to know each other as well. It shouldn't be right. We're only going to get to know you on, the 1st of January, 2026 or whenever it might be. But I do
Yeah,
there is something around probation. We are going to have a look at our probation periods. We're going to have a look at how long they are. We're going to have to think about extending it because, if the window to be able to utilize this modified procedure and this initial period of employment, is going to be 6 or 9 months, or if we've only got, if we've got a 6 month qualification period, that window is so tight. So we need to be thinking
yes,
about how long the probation period is. We need to be thinking about making sure that we get it, we make the decision correctly, we make it justifiable, we make it fair, but we also make it early. What we can't have is, managers being obtuse. Nobody likes to deliver bad news, and managers are probably top at the top of the list on that. But certainly, if we are going to be saying to someone, I'm really sorry, but you've not, met your probation objectives. Well, what are the probation objectives? Have you reviewed them? Have you made it clear that somebody is not meeting their objectives? Have you given them the support that they need to be able to make the grade and hit those objectives? And actually, are you clear in the messaging? Or is it all going to come as a huge surprise to somebody in month
yeah,
6 when you say, I'm really sorry, but we're going to have to let you go. So, and the other important thing is about delay. A lot of the problems we see are around lapsed probation. So somebody who has either passed probation and the manager hasn't really engaged with it. And all of a sudden, at month 8, it's kind of like, oh, actually, they aren't meeting the grade. Well, you sort of said they were, or you didn't really say anything
yeah,
in month 6. But also this idea of lapse probation. So, use the technology, make sure that you've got those meetings in the diary, make sure that your managers are following up. So again, there's a lot of work to be done around training managers. Why is this important? Why do I need to write a letter? Why do I need to have a meeting? All of that good
yeah,
stuff that we need to be thinking about. But certainly
yes,
decision making, isn't it? Having those courageous
yes.
conversations.
Exactly, having those courageous conversations. And again, this ties into that kind of boots on the ground from a learning and HR perspective. Yes, a lot of managers out there are quite junior or quite green about these kind of like performance related conversations and how to handle them. And there's a coaching exercise that needs to occur here. And again, that will feed into, do you have the resource? Do your managers have the knowledge? And even if they do, a kind of refresher is probably on the cards, especially with the new legislation in mind. So You're giving your new cohort the absolute best start they can have. You're giving them the tools. You're giving your managers the tools in order to kind of be those confident and supportive leaders that know how to have the hard conversations as well. And there's a whole lot that goes into this. And you know what? I think this is an amazing opportunity for us to level up. This is a good thing. It's a bit of a headache, but it's ultimately I'm seeing this as a huge opportunity for organizations to just to level up and be those amazing employers of choice.
And to get your managers on board with what you're
Yeah,
wanting to deliver as an HR function. A
yeah.
lot of managers will be told how to do something, but what they aren't told is the why they need to do something. So I think you're absolutely right. This is a huge opportunity for, people leaders, HR professionals to really kind of raise their voice within organizations and get the support. Because, look, if individuals can bring unfair dismissal claims, and if you're looking at potentially 140K's worth of compensation, do the maths. There is some sense into focusing on this and focusing on these issues early.
Exactly. Great.
So how can you help, Azil?
As I said, we're not the pick me up, put me down firm. We have a huge amount of resource and knowledge. And we are here to help you plan and here to help you, plan for the future and navigate these changes that are going to affect all of us. And Emma,
Exactly.
how can you help?
Yeah, no, I think, what I'm sort of, and actually it's kind of, again, echoes what you say as well. People are time poor.
Mm,
And actually, I think being able to provide solutions, effective solutions, strategic solutions to help your business, whether that's reviewing contracts, which we're going to have to do, whether that's reviewing policies, which we're going to have to do. And again, we should be doing anyway. Our contracts, they need to be up to date now, not just kind of what's coming down the line, particularly with rounds kind of legal and leadership training as well, making sure that your managers are on board, they're on the bus with what's happening. Again, I think is a really important thing. And then around kind of strategic support as well, particularly around resourcing, workforce planning, resourcing, I think is some really good things. So I'm all about solutions, and I think actually there is a real opportunity to, HR are time poor, outsource, outsource what you can, because again, focus on the strategy, and
yeah,
as you said, focusing on those strategic
outsource to
conversations.
the experts, outsource to the experts.
Absolutely.
If there's someone out there that's an expert that knows that can do this, why suffer? That's what I always say.
Exactly. Exactly. So we've said, haven't we? Opportunities, huge opportunities, but these are the sorts of things that I really think, we need to be focusing on now. Reviewing. We need to be
Mm,
looking at how we do things. Okay. So reviewing your policies, your processes, your contracts. We should be doing that anyway. Also thinking about settlement agreements and NDAs. There's some changes, particularly around the sexual harassment, and what employers are able to bind out in their settlement agreements. And again, looking at those strong recruitment processes as well and internal talent as well. Again, embedding. This is a really good chance to embed those strong and robust HR processes. I'm really thinking about positives, particularly around performance management. It gets a bad deal. Nobody likes it. Everything is always in the too difficult pile. But again, it's about embedding that culture around supportiveness, around positive performance management. And I can't stress it enough, training. Really getting your managers on board with these changes, what they need to do, why they need to do these, why we're asking them to do these things, and how they need to do it as well. Really important. A particular must is around the harassment, and in particular the sexual harassment. Again, that is a really big takeaway around there's changes to sexual harassment, risk assessments, audits, particularly around that area as well. So get in touch if we can help with that. And again, audit, particularly around the zero low hours changes. Who works for you? How do they work for you? Self-employed individuals, how are they working? And again, thinking about workforce planning. And I would say this is like one of my top takeaways is around what should you be doing now? If we know things are coming in, Okay, what should we be looking at now as an organization around our workforce, planning, resources, contracts, training? What can we start embedding now such that when we get to April, October in 2027, and you speak to your lawyer and they say, it's all a bit more difficult now, what could we be focusing on now? And I guess from your perspective, Aseel, from the recruitment, in terms of what you want to see your clients doing, it's focus, isn't it?
Yeah, it's focus, it's plan, it's ask, put your hands up and ask for support and ask for help. And hopefully something like this has given people in our network a little bit more confidence and a little bit more voice around kind of understanding what's coming.
Absolutely.
Yeah.
So let me just have a look at it. So we've had quite a bit of, gosh, we've had a lot, haven't we? But let's just in the time, because I am conscious of the time. Just Azil, just very, very quickly, just around obviously got a question there around
Mm.
what this means in terms of, could these changes, could they potentially mean that recruitment is going to take longer? What would you say to that?
I mean, yes, it's possible. And is that a bad thing? And it doesn't mean the recruitment process might take longer, but that doesn't necessarily need to be the interview journey needs to be longer. As I said, I think I hinted at this before, we don't need 10 stages. We just need a few good ones. We need to really think out what do we want to know about this person and how are we going to assess them? So, planning the role, planning what you need, planning the sort of skills that you need ahead of going to market with this role is going to be really, really crucial around that. So yes, things could take longer, but I think the longer that time should be allocated towards the planning phase rather than the execution phase. So hopefully that answers your question, and thank you. Yeah, I'm just having a squiz through here, and Emma, there's a good one for you here actually. So what should employers be doing now? So the bill hasn't passed. What if nothing comes of it? So should we bother doing anything
Just
now?
gonna go back. I'm gonna go back. I'm gonna go back. Yeah, I mean, literally, that was obviously written. I'm just going to check with. Yes, I mean that's obviously written from a CFO, isn't it? What's all this? What's all this fuss about? It hasn't even passed. Look, yeah, okay, it hasn't. Right, and as I said, it was supposed to pass in the summer. It was supposed to pass in the autumn. We are now late 2025. But it will. There is too much that has gone into this. There are too many vested interests. We've got consultations that have dropped already. They are recruiting for the chief executive of the Fair Work Agency. There is so much that has already been done with this. And my view, whether it's 6 months, whether we've got a 6 months qualification period, or it's from day one, it doesn't matter. There is an awful lot that we need to do, but just look at this timetable. It is huge. The government are not going to let this go. Manifesto pledges aside, there is so much that potentially happens. So if you have that question thrown back at you, please give them a copy of the timeline and say it's not going to pass. And there is an awful lot that we need to be doing apart from changing probationary periods. Okay. That is one element. It's a big one. Yeah. It's a big, big one. But actually, there is an awful lot more that we will need to be doing. So, yeah, I think definitely there is lots and lots that needs to be done. So keep in touch. Definitely.
Yeah.
Here are our email addresses. Let me know if you want a copy of the timeline. Again, please do reach out to either one of us. And as I said, keep in touch. We're here to help. Outsource where you can, plan where you can, and be strategic. Think about the things that you need to do internally and think about the things that you can get others externally to do. Really focus on recruitment, really focus on the training, particularly around the sexual
Yeah.
harassment and mastering probation periods. I mean, it's huge. Particularly the sexual harassment risk, which I think is very much in certain sectors and for certain employers a powder keg. It's been described as a powder keg. I was chatting to somebody yesterday and they described it in their sector as being a powder keg waiting to go off. So lots of things there.
Great. Well, thank you so much for joining us today. It's been hopefully you found it a very informative lunch break. And yeah, we'll keep in touch.
Thank you so much for having me as well. It's great, Azil. We'll see you soon.
Bye bye.